Today we're going to talk about wrongful and constructive discharge, and within that there is a fundamental concept of employment at will, which is the right of an employer to fire an employee without giving a reason, and the right of an employee to quit when he or she so chooses. So unless a person entered into some sort of a contract with the employer, the law refers to them as an employee at will, or at will employee. And the whole concept of employment at will, uh, it has to do with an efficient distribution of a workforce on the market. It's the assumption that people should be able to choose where they work and for how much, and employers should have the right to do the same. In fact, the principle of employment at will was set forth in Payne versus Western, which claims that, quote, men must be left without interference to buy and sell what they please, and to discharge or retain employees at will for good cause, for no cause, or even for bad cause, without thereby being guilty of an unlawful act per se. It is a right which an employee may exercise in the same way, to the same extent, for the same cause or want of cause as the employer. Now, most of us, and by that I mean about 90% of employees, work fall under the employment at will. Now, that remains 10% of the workforce that is protected by some kind of a contract. Now, public sector employees are usually protected by collective bargaining that allows them to negotiate some kind of a just cause for termination. The public sector employees usually work under some kind of a tenure that also might guarantee them at least a just cause for termination, and a very small number of American workforce work under some kind of a contract, and that would include celebrities, um, professionals such as architects, doctors, etc. And then 90% of the workforce falls under the employment at will, meaning they practically have no protection, and employer may fire them for, as we recall, good reason. That would include the performance, the no reason, or bad reason. For instance, a manager may not like the employee. So all of those reasons are okay. Now, of course, the most desirable reason for termination is the good reason, and that means the performance or poor performance on the part of employee. But of course, we have to remember we need a proof of that poor performance. Now, of course, if we go into the bad reason or no reason at all, well, of course, we're exposing ourselves somewhat to speculations on the part of employee that perhaps the termination had to do with the discriminatory reasons, and that's exactly what we are trying to avoid here. So previously we talked about something that we might call as a rightful discharge, discharge for legal reasons, just to contrast it with the wrongful discharge. So as we mentioned before, it's okay for employer to terminate employee based on poor performance. That's a good reason, no reason at all, or uh, poor reason. Um, but we cannot uh, terminate employees for discriminatory reasons, and that's really what we need to focus on here. Because those restrictions relate to many aspects of Title VII, Title I, and we spoke about it. So, for instance, it would not be advisable for a manager to terminate employee because they don't like somebody's national origin, right? Because they are, for example, arrived from Europe. So that's protected by Title VII, and discrimination against based on national origin. It could be race, also another one. We don't want to terminate someone just because they are women. Of course, here we've got again Title VII protection of discrimination based on sex. We don't want to terminate someone because of the age. Again, that would be the discrimination based on Age Discrimination Act, and so on. Now there are also three other exceptions when it comes to employment at will that an employer has to be aware of. So in other words, we cannot fire someone because of the public policy. Number two, implied contract, and number three, implied covenant. So in some jurisdictions, the courts carved out some exceptions to the employment at will doctrine. And let's start with the first one, violation of public policy. This exception occurs in instances where an employee is terminated for refusing, number one, to commit a crime, number two, reporting criminal activity to government authorities, three, disclosing illegal, unethical, or unsafe practices of an employer. For example, in Palmatier versus International Harvester, in a so-called whistleblowing case, the court awarded damages for the wrongful discharge of an employee who was discharged in retaliation for his reporting to the police that a co-employee was engaged in criminal activity. Another example, in Phipps versus Clark Oil and Refining Corporation, the court found that an at-will employee could sue for wrongful termination after he was discharged for refusing his supervisor's directive in violation of the Clean Air Act to pump leaded gasoline into an automobile equipped to receive only unleaded gasoline. In some states, whistleblowers laws have been enacted to protect employees who disclose employer practices that endanger public health and safety. Number two, implied contract applies when employees are discharged despite the employer's promise, expressed or implied, of job security or contrary to established termination procedures. An employer's oral or written statements may constitute a contractual obligation if they are communicated to employees and employees rely on them as conditions of employment. That applies to written personnel policies, employee handbook, other policy statements used as guidelines for employers, supervisors, have been interpreted as being rules restricting the employer's right to discharge at will without proof of good or just cause. The courts agreed that those types of statements create enforceable contractual rights. For example, in Toussaint versus Blue Cross and Blue Shield, two management employees had been told upon their hiring that they would be employed as long as they did the job. Also, the company's personnel policy manual represented that it was the employer's policy to require good cause for discharge. The court held in that case that such oral and written statements could give rise to an enforceable contractual provision requiring good cause for discharge. And three, implied covenant. This exception occurs where a lack of good faith and fair dealing by the employer has been suggested. By inflicting harm without justification, the employer violates the implied covenant. Discharged employees may seek tort damages for mental distress or defamation. For example, in Fortune versus National Cash Register Company, the court, for the first time in Massachusetts, recognized a common law contract action of wrongful or bad faith termination for an at-will employee. This case involved an employer's termination of a commission salesperson in order to deprive him of benefits and bonuses to which he was entitled. The court was offended by the malicious act of the company at the expense of the employee. The court held that there existed an implied covenant of good faith and fair dealing in certain employment relationships. In other words, when the history of your relationship with the employer creates a duty on his part to treat you fairly and in good faith. So thus far we have talked about rightful discharge, wrongful discharge, and to top it all, let's finish by talking about constructive discharge. Constructive discharge is defined by courts as a situation in which an employee voluntarily terminates his or her employment because of harsh, unreasonable employment conditions placed upon the individual by the employer. For example, unscrupulous employers may desire to rid themselves of seemingly undesirable employees by deliberately forcing on them unfavorable working conditions so grievous that employees would rather quit than tolerate the dischargeable conditions. Now, currently, U.S. Circuit courts disagreed on how employees must prove a constructive discharge claim, and majority of circuit courts favor a so-called a reasonable person standard, under which the plaintiff must merely show that working conditions were intolerable to a reasonable person, leaving the employee with no recourse but to resign. The minority of circuit courts, on the other hand, adopted somewhat stricter standard referred to as the employer intent standards, under which a plaintiff has to prove the motive behind that behavior. This approach, of course, is highly subjective and therefore more difficult for employee to substantiate.